before I begin, sir, I would like to say that these case studies have been framed keeping in mind Schedule 3 of the CGST Act, and basis the judgments and the case laws which are there on this topic. I mean, as of now, this may be the law, and we don't know tomorrow. I mean, if we are relying something which is laid down by the CSTAT, it may get overturned by the Bombay High Court and then by the Supreme Court. So as of now, this is the law which has been laid down by the court. So with that, I would like to go ahead, sir. So briefly to give an introduction, sir, most of us are already aware of this, but still, uh, first we begin with Section 9, which is the charging provision for the GST under the CGST Act. As per CGST Act Section 9, the tax called Central Goods and Service Tax, Central Goods and Services Tax, is levied on supply of goods or services, except on the supply of alcoholic liquor for human consumption. And thereafter, we have the scope of supply, which is being defined under Section 7. It is an inclusive definition. Now, subsection 1A under that section talks about what includes supply. So it says all forms of supply of goods or services. Just one second. All forms of supply of goods or services or both, such as sale, transfer, barter, exchange, license, rental, lease, or disposal made or agreed to be made for a consideration by a person in the course or furtherance of business. And then we have section 7(1)(a), which is recently introduced. Now, section 7(1)(a) talks about what are all the transactions which are there in Schedule 2, which are classified as supply of service or supply of goods or supply of services or both. So Schedule 2 is not something like a declared service where if it is there in Schedule 2, section 7(1)(a), it talks about when certain activities or transaction constitute a supply in accordance with the provisions of subsection 1, they shall be treated either as supply of goods or supply of services as referred to in Schedule 2. So therefore, first it has to pass the test of section 7(1). So it has to be, if we go to 7(1), it has to pass 7(1)(a). So that is, it has to be a supply under 7(1)(a), and then only if it is with the subject to the provisions of subsection 1, then if it is a supply there, then it is being classified either it as a supply of service or a supply of goods. So merely being in Schedule 2, it is of no use. I mean, if it is there in Schedule 2, it does not make it directly leviable to the GST. And then under subsection 2, we have activities or transactions specified in Schedule 3, which are treated neither as supply of goods nor supply of services. So this is what the topic that we are concerned with. So now, therefore, the essential ingredients of GST, as all of us are already aware, there must be a supply. Supply must be for goods or services or both. And then such supply must be for a consideration. That is, there must be a quid pro quo between the parties. And lastly, such supply should be in the course of furtherance of business. Now, this is Schedule 3, with which some of the case studies are based on this. So the first case study, I'll just read out this case study, and thereafter we can have the views. Mr. Double Roll is a highly qualified engineer who is employed by A Limited since 2014. In 2020, A Limited enters into a 50-50 joint venture with B Limited to carry out certain complex long-term infrastructure project. From 2020, Mr. Double Roll's employment contract is amended to give equal control to B Limited. The contract also provides that Mr. Double Roll is equally answerable to his superiors at both A Limited and B Limited, and that his performance appraisal, etc., will be done after consulting his superiors at B Limited also. The contract in this case will be treated as a tripartite arrangement by both A Limited and B Limited with Mr. Double Roll. The salary and other benefits such as PF etc. continue to be administered by A Limited like earlier. However, 50% of the same is reimbursed by B Limited to A Limited on a monthly basis. The question here is GST payable on the amount reimbursed by A Limited by B Limited to A Limited? This is the first scenario. And thereafter, if you can take it a little bit forward, and then the same case study, Mr. Double Roll is deeply unhappy in reporting to multiple superiors across the two organizations. He does not mind continuing the work, but he needs a simplified structure. A Limited and B Limited accede to his request and amend the employment contract to provide that Mr. Double Roll will exclusively be answerable to the COO of A Limited. If any other personnel of either of the companies have any issue with this work, they will be required to take it up with COO of A Limited. Alone, sir. Hello. Hello.
Yes, sir. Yes, sir.
Okay. Sir, I am audible, no, sir?
Yes, yes, yes.
Okay.
Yeah, you are audible. Yeah.
Okay. If any other, so if there is any issue with the working of this Mr. Double Roll, then it will be addressed by the COO of A Limited, and the salary structure and everything continues as before. So what is the GST implication in this scenario? So this is the first case study. If you can have the views of the participants, I mean, thereafter I would like to give my views on this.
Ramnath, Jairaj Sheth here.
Yes, sir.
One question.
Yes, sir.
Is there a dual employment contract at all between the three parties, namely A and B, both issuing an appointment letter of employment to Mr. Double Roll?
No, sir, but it's kind of a arrangement where a tripartite arrangement is arranged between both all the three of them.
Sure, because under the current laws in India, a dual employment is possible.
Right.
So I was just raising this question. Yeah. Okay.
Yes,
Ramanaji, I will go on the basic concept of an employment.
Sir.
Employer-employee relationship or employer or employee. The term employment is not defined in the GST law.
Right, sir.
So would you like to go by the laid down jurisprudence about the employer-employment contract and who is an employee, So I would go to the landmark case of Dhangadra Chemical Works.
Okay, sir.
Wherein the Supreme Court has decided, the Supreme Court has put the test of control and supervision.
Right, sir. Right.
So even if you are working in the capacity as a consultant, not as a paid employee, but if your timings, if your the manner of working, everything is controlled and supervised by your principal, then you may not be a salaried employee on the role of that particular company, but you are still be treated as an employer. The relationship will be that of employer-employee. Here in this our case, the case that you have put in,
right, sir.
The issue here is, see, he definitely an employee on the payroll of A. There is no doubt about it. But our issue is whether he can also be considered as an employee of B also. That is what I think the issue, Ramnathji, you are trying to address. You are trying to raise, correct, sir? If I understood it correct?
Right.
Yeah. So I think, in your earlier slide number 7, you have said, in your slide number 7, you have said, if he is reporting to both the parties, if he is reporting to B also, he is reporting to A also, he is taking instruction from A and B both are supervising.
Right.
To that extent, I personally feel there should not be any issue. It's a contract of an employment only with both the companies, dual employment.
Right.
And the service is provided by that our particular employee to A and B. Both are, in my opinion, may not be falling in the tax karke. But now coming to your second slide number 8,
right,
where the facts pattern are twisted or facts pattern are now changed. you are solely reporting, this particular engineer is solely reporting to company A.
Right.
So
Right,
in
sir.
my opinion, it might be difficult for us to say that he is an, employee of the B also.
Sir,
And only
absolutely
thing is
right.
that can I say that
Yeah.
he's been deputed to be for some work? I think that is
Right,
the
sir.
question. Perhaps, I am not very sure. But if
Right.
I go by the plain this thing, by test of control and supervision, I think my view is in the second case, the again the B is reimbursing to A.
Right, sir.
So is it that a business support services A is taking the is consuming the services of that employee and then providing the services to other, and his reimbursement concept is only nothing but a quantifying the value of the
Right.
consideration for sharing that employee, sharing the giving the services of this employee. So that could
Right.
be a taxable. I think these are the views.
Can I
Right,
add
sir.
something to this, sir?
Sure, sir.
The Dhangadra chemical which Naresh Bhai has referred, which is very important, which is although the decision was vis-a-vis Industrial Dispute Act, but it has given listed various factors which indicate the relationship between master and servant.
Okay,
And
sir.
there are a lot of factors that right to appointment, right to terminate, right to take action, right to prescribe various condition of contract, nature of duties to be performed, etc., etc. So who dictate the terms that he will be the employer of that particular person is the factors that Dhangadra Chemical has stated. Now, in
Right,
your
sir.
case studies, if, there are two case studies in this. So, in first case, it is a joint employment because they have changed the contract and both are 50-50 JV, and they have appointed jointly this person because they have suitably amended the contract to that extent from your case studies. And
Right, sir.
it is only the administration that of making payment of salary as well as PF dues, etc., is done by A, and which he recovers from B. That recovery is only toward the cost, which is otherwise the liability of B only.
Right, sir.
So it is a joint employment, and so in case of joint employment, when one employer is recovering the amount from other employer, is nothing but it is a salary reimbursement, and there cannot be a tax on that amount. This employee is attached, or rather he is rendering services to two employer, and that will fall covered within that entry number 1 of schedule 3, and there will not be any tax liability. There is on the similar facts, there is a one UK decision of AstraZeneca versus HMRC, and where it is, of course, there also this transaction is liable for UK VAT or no, that ECJ citation is there C40, and where it has almost on the similar fact in UK law also, this is not a tax, and where multiple person can have same person on his payroll. So it's a joint employment is possible.
Right, sir.
This was about the first
First
issue.
one. Yes, sir.
And on coming to the second part is concerned, here the your facts says that the employee got fed up with the contract and he has requested that I can't report to both, and they have suitably amended the contract. Thereby now he is responsible and accountable to only A Limited CEO, and but still he has to perform the duties which is required by B Limited, but B cannot dictate the term. Means any issues B has got, it has to be routed through A Limited CEO. That is what the facts coming up.
Right, sir. Right.
And
Right.
if that being the case, this person is not in a contractual obligation or relation with the B Limited, cannot be an employee on that front of B Limited with the facts narrated by you in the question. And so the recovery by A Limited is, to my view, is control, possession, and all the other conditions of the employee is laid down in by Supreme Court in Saurashtra is concerned. This person will become exclusive in employment of A Limited in the second case. And what he recovers is the manpower supply charges, because he is providing this person to give some work, because he still continue to work for B, but under the guidance and control of A Limited. So in the second case, whatever 50% recovery is there, that will be not be covered by Schedule 3 item entry 1, but it will be a taxable supply of service in my view.
Right, sir. It
And
will
to
not,
support in the old law, there were quite a few decisions of similar kind, but one of which is a Volkswagen India of Mumbai Tribunal. almost, but it is vis-a-vis old service tax law, but there also it was a kind of a joint employment, and that turned out to be a manpower service while the taxing.
Sir, right, sir.
That's all. Thank
Yes,
you.
sir. Yes, sir. Yes. So I'll just go ahead with the next slide, sir.
Ramnath, Ramnath, sorry,
हाँ,
Jairaj bhai's comment was there on the chat box
हाँ sir.
that while considering the employment, should you consider the definition of employer-employee under the Factories Act or other such act, Industrial Dispute Act, etc., etc., etc. Jairaj bhai, my limited understanding is the Factories Act or Industrial Disputes Act are under some different for some it's in some different context. It is not pari materia the tax laws. So can we directly import the definition, or can we directly apply the definition of that particular act to the taxation law? I think Ramnath has to explain us this particular.
I don't think we can rely to whatever extent that is useful to us, but the thing is that most of the definitions are deemed definitions where they are in relation to that act they have defined who is an employee and an employer, so that can't be like like a universal test for an employer.
Sir, there is a.
It is basically has to be basis the conduct and the conduct of the employee, the relationship between the employee and the employer basis the conduct. Sorry, it could be a contract, but the courts have generally gone by the conduct of the employee and the employer.
Sir, Mr. Subramaniam has raised his hand, so I am allowing him to raise his points.
Yes.
Yeah, Mr. Subramaniam, you can unmute yourself and raise your points.
Hello. Am I audible?
Yes,
sir. Sir, in the first case, you know that the salaries and other benefits, PF, etc., continue to be administered by A Limited. Is continued to be administered by A Limited. However, 50% of the same is reimbursed by B Limited to A Limited on a monthly basis. So, is it not a supply of services by A Limited to B Limited? Because what A Limited is supplying the services and receiving the consideration from the B Limited only for supply of service. No doubt, there is an agreement between the tripartite agreement, etc. But what is the exact transaction? The exact transaction is I am supplying the manpower or supplying my employee to do the work, and I am receiving a consideration. Whether still it will be form part of a salary is my question, sir.
Yes, sir. There is no doubt that the employee is providing a service, but the thing is that if an employee is providing a service to an employer, which in this case is being providing in the first scenario, in that case, it gets covered under Schedule 3, Para 1 of the Schedule 3. So that way, it does not amount to a service. We cannot say that A Limited is providing a service to B Limited by through this by arranging this employee or this person to be limited. It is the case of joint employment where there is one employee who is providing his services in the course of employment to two employers. One is A Limited and the other is B Limited. So inter se between A Limited and B Limited, it is only the sharing of cost that happens, and there is no service that is being provided by A Limited to B Limited for which he is getting paid.
Can I just add to the confusion a little more?
Yes, sir.
If we know the judgment of the Supreme Court in Aditya Vikram Birla in Section 80 RRA, where there was a benefit given of a person employed with a foreign company to have a deduction if he's earning in foreign exchange. And Mr. Birla was appointed for some 3 years as a technician or as a consultant. and the Supreme Court and the Government of India's approval was required on that employment contract or on that contract to be eligible for the benefit of 80 RRA. So the Supreme Court division bench held that even a consultant or a technician of this nature that Mr. Aditya Birla was employed, and there is an employer-employee relationship in the context of Section 80 RRA, and they
Yes, sir.
allowed the deduction.
Yes, sir. That is
So-
looking at the conduct of the employee.
Unfortunately, at least the Supreme Court judgment doesn't discuss the conduct. If we read the High Court judgment, maybe we will get a little more clarity. But yes, there was a situation where somebody was a consultant or a technician by nomenclature, but allowed to be treated as an employee for the purpose of 80 RRA benefit.
Right.
So Ramnathji, there is, I think the viewers are having the, your first part, 7 number, slide. People are very clear, he's an employee of both the company.
Right,
But on
sir.
the second, slide number 8, where you change the facts,
Ah,
I
Yes,
think,
sir.
we require sort of your views on that.
yes, sir. Sir,
So,
yeah. So here I would go again by the control and superintendent's test. I mean, he is not in this case, the employee does not seem to be like personally liable, because one of the test is that, hire and fire. If at all I do something on the job, I'll be fired from the job. That fear does not seem to be here. If there is anything that be reported to A Limited, and then A Limited would either call him back, and then there would be somebody else who would be deputed in his place. So therefore, here it looks more like a, manpower supply kind of an arrangement, than direct employer-employee relationship between uh, uh, the employee and B Limited. So when that test fails to some extent, I mean, it is slightly difficult to say that it is covered under Schedule 3.
As regard first case study, you agree to that? It is a Schedule 3 item.
Yes, sir.
Joint employment.
Yes. Joint employment. Yes, sir.
Ram, Krishnan here.
Yes, sir.
Yeah, on the first matter, have you come across any live matter? Because the problem will be the TDS, income tax.
Right,
So,
sir.
will income tax will be deducted by A Limited on the full amount, or they deduct on the 50%, B will deduct on the 50%?
That as such in the case law, it is not there, sir. The case law which fairly covers this kind of situation is Franco. Where
Which
they have
one?
to-
Franco?
Franco.
But Krishnan sir, one thing is that in my view, if two employers are there and if only one employer is deducting TDS and taking responsibility and care of the income which is given by other employer by of salary, it is treated as compliance to the TDS provisions. Means A should take into account the salary which is paid by B Limited. Thereafter he should compute the total income of employee and he should deduct the TDS accordingly. Then there is no requirement that B should deduct the TDS.
Yes, sir. And in this case, anyways, the salary is paid by A Limited to the employee. It is only that part, 50% is being reimbursed thereafter by B Limited to A Limited.
No, my thinking is the whole purpose is it's for convenience that A Limited is paying.
Right, sir.
A Limited is a payment conduit.
Right.
So even though it is paying on the full amount, and if it is mandated with it on a tripartite arrangement, then it is invariably B's expenditure.
Right.
And if B is paying in effect, payment doesn't mean physical payment. It
Right.
can pay through A. So in effect, actually, they are paying it through A. So B should deduct on 50% and A should deduct on 50%. Because that 27 A's is also going to the GST department. So on the safer side, one would say, ideally, both should pay their own amount directly to A. But if that's not feasible, then this is one method because TDS is on expenditure. We have to just check up because I think in case of 194H and 194C, there is a difference between payment and expenditure. And if it is on expenditure, then TDS has to deduct by B. But if it is on payment, then I think there could be an issue here. That's all I wanted to just see. You have come across any actual thing?
No,
What
sir.
is happening in any companies which are really happening?
No, sir, not as such.
Ah,
Really. I mean, as a live case study.
I feel they might relevant companies might deduct the relevant. There's a possibility. I'm not saying 100%, but that possibility is there. Anyway, the sum and substance is A not liable, B liable.
Right, sir.
Right?
That's how we can conclude. Yes. So I'll just quickly go on to the next slide, sir. So these are,
Yeah.
I mean, we have discussed all this, but just a slide to say that general test is that there should be a contract of employment. I mean, again, without there being a contract as such on the conduct, but on the safer side, there should be a contract of employment. Employer should have the right to hire and or fire the employee. Payment of remuneration is directly or indirectly. Employer should be responsible for payment of deduction of taxes and other statutory contributions. And employer should not only have control over the work to be done, but also the manner in which it is to be done. So these are generally the test for an employer and employee. And
So,
even there is, yeah.
Sorry, Ramnath. So it is in this very context that I had thought that in the first scenario, to avoid any dispute, if the parties had actually issued two appointment letters,
Right, sir.
and instead of claiming reimbursement, all the problems would be solved. So the answer to Mr. Krishna's question is that the arrangement which is described in that is something which could be litigious. Therefore, it is better to issue two appointment letters and move ahead. So no dispute at all.
Yes, sir. So in the case of Franco, this is what the tribunal has held, as what you said now. That is, if at all there is a separate, I mean, employment letters has been issued, then the department wouldn't have had any problem. So it is because of this arrangement. Nonetheless, they go ahead and hold that it is nothing but a service of an employee to an employer and hence excluded from the definition of service. But they say that if that would have been the case, then there is no issue at all. So,
and some parties do enter into such arrangements, especially some multinationals. They do this. They have dual employment letters. When people come on secondment from abroad to work for the Indian associate company, they issue them two appointment letters, and the first appointment letter is kept as a sort of in hibernation. But here you want an active appointment letter for both the employer A and B.
Sometimes maybe even the employees may not be willing to have such kind of an arrangement where.
Agreed. I agree.
Ramnath, there is one more point in the first issue, that this being a tri-party agreement, for any month, suppose A doesn't pay the salary, the employee cannot claim 100% salary from him. He can claim only 50%. Balance 50 he has to go to B. That itself proves that my liability is only to the tune of 50%, irrespective of TDS and all.
Yes, sir. Yes, sir.
See, there has to be the contractual obligation is that I will be paying 50%, you are paying 50%. So just because you are paying for administration 100% doesn't make you liable to pay 100%. Tomorrow, if you don't pay, the employee has no claim against you.
The extent of 50% only he can come to each one.
So that means he is in employment of both.
Right.
The TDS could be income tax issue, other contracts, etc. The contract is very important, which you stated. It is tri-party contract.
Right, sir.
No, but Rajiv, even if tri-party, if it is joint and several, then
joint and several is fine. But I am sure, sir, the drafting of the contract, the fact is that tri-party, in his facts is concerned, 50% I am responsible, 50% you are responsible.
Fine. I think we should go to the next. Because there's a lot, we have to cover a lot of.
Yeah.
Yes, sir. So then again, a similar judgment of like what we discussed of Supreme Court in Workmen of Nilgiri. So they basically go by the control test, and they say that there is no single test, but there are many factors that would generally has to be considered, and they lay down all this: who is the appointing authority, who is the paymaster, who can dismiss, how long alternative service lasts and all those things. And then we have under the explanatory notes to the scheme of classification, I mean, the service code, a couple of service codes include one is 998514, supplying personnel for temporary work assignment. So if you see the language over here, it makes it very clear that, you know, it is what I have highlighted here. The employees are on the payroll of the temporary staffing firm, but which is legally responsible for their action. But when they are working, they are under the direct supervision of the client. The client may be supervising them because he's working with them, but the payroll, they will be of that who is being sending them to the client, and also who will be responsible for their action. So these are all where, you know, it could be a situation of manpower supply and not a plain Schedule 3 employee rendering a service to an employer in the course of his employment. So similarly, a long-term staffing payroll, it is also worded similarly, where it is supervised by the client and placed on the payroll of the staffing firm, which is legally responsible for their actions. And so this is, in the present case, is in relation to joint employment, where an employee is employed with more than one employer. So, so joint employment, generally, one employee is employed with more than one employer. Both employers are able to exercise independent control. Both employers stand to benefit from the work done by the employee. Each employer pays his share or emoluments, or one of them pays on behalf of the other employer and recovers the same on actuals. So it could be either like what Gerard sir was mentioning, joint employment paid by one employer and reimbursed, or paid by each employer respectively by entering into a separate contract. That is also possible. So here it is a case of Franco. The Franco, it is slightly different from other cases because in the case of Franco, it is after 17/2012. There are many judgments where the courts have in fact gone into the definition of manpower or business support service, and thereby they have ruled that it does not satisfy those services, whereas the employer and employee test has been in fact clearly considered and laid down in this Franco judgment. This is, in this case, it was the Franco was a manufacturer of pharmaceutical products, and there were three related companies that did not have their own marketing network. So they used the marketing network of Franco, and Franco deputed its employees to the group companies for marketing, and recovered all the cost, wages, bonus, incidental expenses of the employees. Recovery of such cost was based on the business turnover of each of the group companies. And it was the case of the revenue that this is under the business auxiliary service. Some part of it was after 17/2012. So therefore, whether the test of employee came over here, you know, because this what we see in Schedule 3, Para 1, that was there as an exclusion under the definition of service earlier. So here it is, the tribunal observed that it is undisputed that the products were marketed by Franco's employees sent on deputation. Agreement talks about lending of services of employees required from time to time. Deputed employees were governed by the rules, terms and conditions applicable to that group companies. That shows that they were under the control and supervision of the group companies. And the sales made by the deputed employees were considered as the sales of that group company alone. And any complaint regarding any sales made by them were to be addressed by that group company alone, and Franco was not responsible for that. And after the job is done, they would, I mean, after the end of that employment contract, they would go back to Franco. And then it goes into the legislative design after 2012, 17/2012. So service rendered by an employee to one employer or many in case of joint employment cannot. So it says that how the emoluments are routed, that is, I mean, Franco paying it to the employees, and thereafter it is shared by, I mean, by the group companies, that is routed through Franco, that will not make any difference. And it says that revenue would not have had any objection if the employment contract was signed jointly by all the companies. And if the employer companies were paying their respective shares directly to the employees, so there would have been no issue at all. The issue came only because it was paid by Franco and thereafter it was reimbursed by this group companies. So, yeah, so So that is how they conclude, and they also go into the fact that there was no markup on the expenses that is being reimbursed. So since there was no markup, so they are saying that it was only on a sharing of cost that has happened of the employee cost, and therefore it is service rendered by the employer to the employer in the course of employment, and therefore it is not liable for service tax. And this was in fact, and most of us are aware of this Columbia Asia Hospital AAR, which is in fact there the Franco was cited, and it was only discarded saying that it relates to a service tax regime. So here it was a case of where the employees were at the corporate office and carried out some activities like accounting, administration, and maintenance of IT, the benefit of which would flow to the entire company. So it was the common expenses were generally charged by, cross-charged by these by the corporate office to the other units. But insofar as employee costs were concerned, they said that it is an employer-employee relationship, and it is when a company appoints an employee, it is for the whole company as a legal entity. And just because he is located at one state, it will not make any difference, and it should cover under the Schedule 3, Para 1. But the AAR said no, it is an employer-employee relationship exists only with the corporate office, and the corporate office and units are distinct person, and the employer-employee relationship has to be viewed separately from every registered unit. So that's discarded this Franco. So to that extent, this AAR, I think it is challenged before the High Court now. So it is not. The view taken is incorrect in my opinion. So to conclude, in the first scenario, it is a case of joint employment where the employer B Limited has complete control and supervision over Mr. Double Roll and his work. Therefore, in the existence of employer-employee relationship in undertaking the work, the cost reimbursed by B Limited to A Limited is not liable for GST. And in the second scenario, the control appears to be only with A. It's ultimately O is responsible for the work of Double Roll, as the CEO of A Limited has assumed overall superintendence and control over Double Roll. Thus, in the absence of employee-employee relationship, one can argue that this transaction is not covered under Schedule 3. So this is about the first case study, sir. I'll go with the second study, sir.
Please, sir.
Yes,
please.
yes, you need to go to.
Okay.
Yeah.
Okay. Yeah. So these are just a hypothetical cases. There is a portal by the name Strategy Games Limited. It's an online portal, and it conducts two kinds of games. One is where the participants could register for an online chess game, where before the commencement of the real match.
Okay.
So before the commencement of the real match, suppose say there is a match that will be conducted tomorrow between Magnus Carlsen and Vishwanathan Anand. That's the real world match which is happening tomorrow. But today, before the contest closes, the participants have the option of depositing money in this online portal towards one possible outcome of the three. That is, who will be victorious in the sense whether it will be Magnus Carlsen, or whether it will be the victory secured by Vishwanathan Anand, or it will be a draw between the players. And this online portal also provides certain data analytics, like, to make some decision making to the participants. Like one can look at their ratings, how well they are, how many times they have played against each other, and what is the advantage which Anand has over playing white, and vice versa. So these are some of the data that would be provided in the portal of strategy games. So at the end of the game, the amount that is being deposited will be distributed among the winners. And there will be some nominal charges, that is at the rate of 10% of what is being deposited will be deducted by this online portal, and a GST invoice charging GST at 18% will be issued to the participants. Now the department says that the GST has to be discharged on the entire amount that is being deposited by the participants. So this is one, the first scenario of this game, or the first game that they are conducting.
Ramnath sir, we should stop at first and take view, then you can proceed to second.
Fine.
That is better,
Yeah.
rather.
Yeah.
My apology, but that is better strategy.
Yes, yes, sir. So is the department right in saying so, sir?
May I add something here?
Yes, sir. Please.
See, in your case studies given, you stated that it's a real-time game of chess going on, and as a participant of this game, I am fully aware who is going to play against whom.
Right, sir.
Plus, I also know the skills and the features and the track record of both the person who is playing the game, chess game in this case,
Right,
and
sir.
certain points of advantage, etc. So
Right.
if I had to participate in this based on the experience, track record, knowledge, and various other factors, I will definitely opt for either Vishwanathan or whatever it may be. There'll be some justification and basis. There'll
Right.
be track record, etc., whatever, but there is no luck. I mean to say, there is no game of luck or chance, but it is something which require a skill. The player who will have better skill or better circumstances will be winning the match by and large. I mean, to that way the game will be tilting to. So player also will be going by this thing. So it cannot be treated as a betting or gambling to that extent, since it require skill. The outcome will be by and large on that front, and thereby it will be although actionable claim. But those three items which are actionable claim is outside the purview of Schedule 3, except those three items: lottery, betting, and gambling. So there is no lottery here, there is no gambling here, and no betting here. In my view, it should be game of skill which I am playing. And there is a decision to that extent, but not vis-a-vis the taxation law, and where the Dream 11 related matter of Gurdeep Singh Sachar
Right,
of
sir.
Mumbai High Court, and there it has been distinguished and saying that it is not a illegal or gambling. Dream 11 is. It also requires skill when you select the team or players, as the case may be. So that's why in my view it should go out of the purview of GST liability and will fall under that entry number 6 of Schedule 3.
Raju bhai, slight difference of view here.
Yes, sir.
Definitely it is not a gambling. Definitely it's not a lottery.
Yes.
But about the betting,
Yes.
see, even if you are betting on the cricket,
Yes.
you know the Virat Kohli's track record, you know Rohit Sharma's track record, you know bowler's track record. So definitely the knowledge of the cricket will definitely be required even while betting. Even if you are betting on the horse, you know the Janam Kundli of the horses, you know.
Yes.
The skill is required even in the betting also. So simply because I know the somewhat chess and I know the Vishwanath Anand or other grandmaster, but still what I am doing, I am betting, you know, in the sense, I am not riding on my own skill. I am depending on, I am betting who will win the game or who will lose the game. So I would be, you know, slightly be cautious while saying that it falls under schedule, that entry number 6 of the Schedule 3, because betting means you are betting on somebody else. So it will be a betting. So betting ke liye I am slightly of different view. And about that, you know, Sachar case was basically, you know, that was on that sort of, you know, okay, whether it is activity is legal or illegal.
Yes, yes.
Here there is legality. Illegality is not a, you know, in the taxation law, the legality, illegality, I think is not a criteria. So Rajiv, slightly I have a different view. Ramnath, I have put my view, you know, sort of.
In that High Court decision of Sachar, no, there is a passing remark of GST. I know that matter was nothing to do with the taxation law.
Yeah.
But it has talked about the Schedule 7 supply, etc. It has spoken. That's why I just add up to that Sachar's case. But I personally feel ki, as against the other, you say it is a luck, etc. I will say it is not the luck, it is skill also which works, because in Dream 11, sir, you have option available. You select the best out of it based on the track record, etc. So that skill you must be having it, sir. Naresh bhai, if you are well aware with the chess, okay, then only you can select Vishwanath Anand or the other person.
I agree with you. I agree with you, but still it is a betting. If I would have playing with the Vishwanath Anand,
yes,
or and then then perhaps it's a game of a skill.
Okay.
But I am not participating in that game.
Yeah.
Somebody, two different players are playing the game, and I am putting my money on one of the players.
Okay.
Yes.
Fine.
So I think that is the difference. That is the difference.
So,
Okay,
sir,
fine.
Sir,
Fine.
so when we are saying game of skill or a game of chance, so we are looking it from the perspective whether that chess is a game of skill or is it the, I mean, the game which is being played by the participant is a game of skill. So according to you, what do you think, sir?
Sir Ramnath ji, I will put it this way: both are game of skill. Obviously, chess is game of skill because the person has to have skill to win the match, etc.
Right.
And as far as I am concerned, I know both both the players are expert right now in your case study in the game of chess. And only I have to decide, I have to judge who will be winning this match looking at these things. Like today also in cricket, suppose Virat Kohli is in the best form, I'll select Virat Kohli. Maybe somebody Dhoni is not in good form, I may not select for my team, etc. So it's all based on the performance. But who will judge it? I should know the cricket, I should be aware about, etc. A lot of other this thing. Then only I'll select the player. So selection of the player also require the skill. So here also, if I am tilting toward Vishwanath Anand's victory, though I should know the track record and other advantages, etc., disadvantages, and then only I can select. No, sir.
Right, sir. But
Rajiv
ultimately it would come
Bhai,
down-
sorry, Ramanath, only 1 minute. The skill and other thing, I think it was in a service tax era, it was more relevant. But here in the Schedule 3, there is no reference of the skill, etc. They are simply saying lottery, betting, and gambling. So betting, whether it involves the skill or not involves the skill, I think betting remains the betting. That is what my view. And this, if we have to perhaps we can't introduce why we can't insert the words like skilled, etc. while interpreting this entry. That is what my perception is. Yeah.
Sir, if I'm permitted to add something,
Sure, sir.
sir, I haven't practically gone through what is Dream 11, but what I believe from the advertisements and everything, based on the past track records, based on all the performance and everything, you are going to pick a team. Basically, you are going to pick what would your team would have composed of, and if that player performs, you are given appropriate points, and the team that scores the maximum points gets some money. So that's the concept of Dream 11. I am not betting in Dream 11 on a performance of an individual player. Let's say I have picked Virat Kohli in my team. There is no bet that he will score 50 plus, or whether he scores a century, or he will get out on zero. So there are track records and there is skill set involved in even making the bets also. I have to see what things have happened in the past and everything. There is definitely skill set at the hands of the better. But as far as your Dream 11 is concerned, I think little bit factually it may be differentiated from the front. There is no bets that are placed that this particular player will perform or a particular event will happen. So I believe that is the what we're deriving from the term bet, that I am putting my money on a particular event happening, whether Vishwanathan Anand winning, Magnus winning, or a draw happening. So there are particular 3 events that are going to happen. There is no 4th outcome. Whereas in Dream 11, there cannot be any, I believe there cannot be a particular outcome. There can be n number of outcomes with n number of players, your choices and everything. So I believe little bit there might be a bit of distinction. This case might come, in my view, under betting scope.
So you mean to say that in the case of Dream 11, it is a game of skill. There is no dispute at all. It can't be termed as a betting.
I wouldn't say it's not. See, there's a game of skills everywhere. Even betting involves game of skill.
Right.
You need to have some skill set whenever you're putting bets. Even when I'm putting my bet on a particular set of outcome also, that also requires some skill, because I need to know how this player is performing in the past, just immediately prior, what was his track record, everything. Looking at his current posture, I had to determine how much confident he is looking, all those things. A lot of things comes into play. So
Right.
skill set is definitely involved in betting. But again, in betting, there has to be definite outcomes. 1, 2, 3, 4, whatever outcomes. I'm betting on a particular outcome, either this or that. Dream 11 is not, I think, dependent on a particular outcome. It's a combination of multiple events happening.
Right.
And that once you choose your players and do all those things, how much that player scores, accordingly he is given points, and accordingly all your 11 players, how many points each player has scored, that is your team total, and that is how I think you get into Dream 11.
Okay.
So it's not one particular event I'm betting. It's not like I'm betting on Royal Challengers Bangalore winning or Deccan Chargers losing or the match going into a draw or super over. I'm choosing my entire different team, hoping that these players score.
Right.
And on the performance of all 11 players involved therein collectively. So a person may score 30, he may score 10 points, he may score 40, he may score 15 points. I am not betting on any of those outcomes. I am just putting my skill to compose the best team possible.
Right. You are acting as a selector.
Yes, I'm stepping the shoes of the selector, kind of.
Okay. So here
I'm not betting towards any outcome. There is no bets towards any outcome. Only thing that I'm hopeful of is my team scores the maximum points.
Okay. Okay. Right. Okay.
So that is how I would a little bit have a bit of distinction between Dream 11 factually as well as this. I definitely haven't gone through the judgment of the Bombay High Court as Rajiv sir suggested over here. So I wouldn't know what is the exact passing remark made by the court or what are the observations made by court. But on a factual basis, I think little bit distinction. This is where I would draw the line. Sir.
In fact, they have said that it is the pooled money, what is being the deposit which is being pooled by all the participants. That is nothing but an actionable claim, and this does not amount to betting and gambling, because this is a Dream 11 is a game of skill. That is, the participants are participating in a game which is of skill and predominantly a game of skill and not a game of chance. That is what they have concluded. So even though it was a criminal PIL that was filed, it was that they are not paying the correct GST over there is what the issue was. They should have paid the correct GST as per 31A. That is on the entire deposit that they are making. So that was the issue. So the court has gone into these aspects and then it has concluded that it is a game of skill.
Ram, Jairaj here. So you mean to say that the court concluded that it is an actionable claim because there is an underlying debt to distribute the money to the winners, right?
Yes, to the extent of what is being deposited and which has to be shared among the participants.
Correct. Now, in the unfortunate event of a winner not being traceable because of some terrorist attack, he has died. After he has betted, he has gone on the portal and put his money at stake.
Right, sir.
And the money is not distributed to such winner because now they are unable to trace him.
Sir.
What will happen to that money?
Well, in the case of Dream 11, I am not very.
No, generally, what would the gaming company do? Will it give it to charity or will it retain it? If it retains, then the answer change in such an outcome comes.
It may choose to retain it, sir. Yeah.
And will our answer be therefore different if it has it? Because if it were a debt,
Jairaj sir.
Yes.
Jairaj sir, what I have been told here ki once you participate in Dream 11, through your wallet you have to make the payment. Whether you are alive or dead, the money award will come back to your wallet, sir.
That's what I'm saying. Many times due to technological failure, supposing my wallet is now not traceable, somebody has hacked my wallet. I'm talking about a very, very extreme situation because ultimately our answer has to be the same in any situation, correct?
But in what context, sir, if the amount is not being...
So, for whatever reason, if the winner and his wallet is not traceable, and therefore the gaming company is unable to distribute the prize money to the winner, then will our answer change?
It will not change, sir. It is, how can I put it? In any, the winner any which way will getting his money, but because of this unfortunate event, if the amount is not being, for whatever reason, it is not being transferred back to his account, that will not change the way in which the game is being played.
So therefore, absolutely correct. And therefore, such a contingent event ought to be described in the terms and conditions when the participant participates, as Rushil is right now putting, that if the winner is not traceable, the company will trace his legal heir. And if he doesn't have any legal heir, he is the only one, he doesn't have wife, children, nothing, then the company will give it to the government of India or to the government of that country. Because if it is a debt, I can't retain it, no. So my point is that the terms and conditions ought to be read, that whether such a contingency is provided for, and if it is so provided that the company will retain it, then there is a problem.
Okay. It is not an unsecured, I mean, in any case, it was an unsecured debt, sir, but because of this unfortunate event, it couldn't be given back to, I mean, to the winner. That's what the difference is in this case.
Yeah.
But the contract would generally provide, sir, where, you know, it would be given to the legal heirs or a nominee or someone who would be appointed.
Absolutely correct. Yeah. It should consider that. It should provide for that.
Yes, sir. Yeah, to be more safer side, you know, to satisfy what is an actionable claim.
Precisely, that is my point. Absolutely correct.
Okay.
Yes, Ramdassji, your view?
Sir. Sir, should I go into the second?
I think first you can give your view, then you can go to second, then so that
okay,
better.
Sir. Okay, I'll just go to the slide over here, sir.
Yeah.
So yeah, we are talking about this actionable claim other than lottery, betting, and gambling, and actionable claims are kept outside GST in the sense it is an activity or transaction which is neither supply of goods or supply of service, except there are exception is lottery, betting, and gambling. And goods anyways includes actionable claim, and actionable claim, as what Jairaj sir was saying, it's an unsecured debt. So I'll not get much into this. Yeah, and these are the examples of actionable claim. And so now, if we see one thing, sir, over here, 31A, I think Naresh sir was talking about gambling is understood that there is an involvement of chance, but not with regard to betting. So, but if you see over 3 over here, 31A3, it talks about the value, how do you value the supply in the case of lottery, betting, and gambling and horse racing. So it says the value of supply of actionable claim in the form of chance to win in betting, gambling, or horse racing in a race club. So they have fortunately qualified this valuation provision where, you know, the 100% of the deposit amount is being made liable for that is the face value liable for GST by qualifying with the word a form of chance to win in betting. So actionable claim in the form of chance to win in betting. So they have qualified it. So therefore, we can proceed on the basis that there has to be an involvement of chance. In case of even if it is a betting where one can say that, you know, there is, I mean, betting it's slightly difficult to say that there is an element of chance. And gambling, yes. So this is one thing where I would say that, you know, there has to be a chance to win. So this chance is something has to be read along with this betting and gambling. And then again, if we go by the erstwhile definition of betting and gambling, how it is being defined, it again talks about means putting on stake something of value, particularly money, with the consciousness of risk and hope of gain on the outcome of a game or a contest whose result may be determined by chance or accident. So the chance or accident is something that goes along with this betting and gambling. So, and even the other definition of gambling also, if we see under the Black's Law or Britannica, they all talk about an involvement of chance, and it's the outcome is not known in the sense, you know, it happens by accident. So, but now if we see the Maharashtra Prevention of Gambling Act, so which is applicable in the case of betting and gambling. Now there is a savings clause. Now that savings clause provides that nothing in this act will be applicable if at all in the act shall be held to apply to any game of mere skill wherever it is played. Now the problem which was, I mean, before the Supreme Court in the case of Lakshmanan's case, if you will see in the next slide, was that what do you mean by this mere game of skill? I mean, can there be a mere game of skill? So the court said that there can't be, I mean, at least not many mere game of skill or a mere game of chance. It could be at best predominantly a game of skill or predominantly a game of chance. There could be some degree of, you know, chance involved, whereas a substantial degree or a higher degree of skill, and that is how we see whether it's a game of skill or a game of chance. And so, even if we see the game of the cricket for that matter, where, one cannot disagree with the fact that it is a game of skill. But, it happens with the toss of a coin where, there is some involvement, and basis that one would take whether you want to bat first or ball first, so that advantage is always there in a chess while playing white or, playing black. So all that some element of chance is involved. So mere game of skill has to be read to mean that it is predominantly a game of skill or predominantly a game of chance.
And additionally, I also believe that the moment you say something is a game of skill,
Right.
ordinarily skill will precede the selection of the chance, and there you need the skill to select which particular chance you or outcome you want to select, and thereafter the outcome happens based on your luck. So
Yes, sir.
it is not the other way around. If it is other way around, then there is a problem. The skill has to be involved prior to the outcome. Then it is easy to justify that it is a game of skill.
Right. So this is what basically the court has said. It is the predominant element what has to be considered in determining whether it is a game of skill or game of chance. So now
No,
here,
I wanted to beg to differ from the court more than predominant. What is
sir.
preceding? I thought what is preceding is important. There, as Naresh Bhai was saying, if I have to bet on a horse race, I have to know what is the progeny and who was his father, mother, etc., and how many races he has won, and then I select which horse. So there is a skill involved in doing that. If I am playing rummy, I must know how to place my cards, right? How much I should be doing, or poker, or anything of that nature. So if the skill is preceded, but in poker, for example, the chance is first. The cards are distributed. So what you get in the card is your luck, and thereafter you apply your skill, and that is where the difference lies. That yes, predominantly it may be a game of skill, somebody would say, but first, which cards will you get is a chance, and thereafter the skill comes into picture, and that's where I think there is a difference.
That's a fair argument, sir. But the only thing is that that may become slightly difficult in all the games to convincingly put whether it is what comes first, whether it's the chance or whether it's the skill. So the court has primarily gone what is predominant overall in a particular game. So as long as it is a skill or if it is a chance, that is what determines what sort of a game it is. So, horse racing, as you rightly explained, sir, it has been held to be a game of skill because there are many factors that the participants have to take into consideration, like, as you said, father, mother, progeny, and how many races it has participated, how many wins the mother has won, father, and also the jockey and the fitness of the horse, its training, and all those things are being covered. And therefore, the court has, in this case, held that it is a game of predominantly a game of skill and not a game of chance. But here, one thing what I would like to point out over here, sir, and therefore, as we'll go by what the court has said, it is not a betting or it is not a gambling, and it is a game of a skill. Now, if we come back again to our yeah. So here, as we know that the exclusion is of actionable claim, except for lotteries, betting, and gambling. Now the court says that horse racing is not a betting or a gambling, and anyways, it is not a lottery also. So whatever amount that is being pulled in and by the participants, except for that commission, what is deducted, one can say that there is an element of service, and rest of the amount is nothing but an actionable claim, and therefore it is fairly covered under the this para of actionable claims other than so and so, and therefore what the tax is payable only on that element of commission and not on the actionable claim. But if you read the rule says it goes something, and it goes even beyond the parent act what it is being provided. Now the parent act says it's only betting and gambling. Now we have the court saying that this is not betting and gambling, horse racing. But if you see rule 3, it says the value of supply of actionable claim in the form of chance to win in betting, gambling, or horse racing. Now, from where did this horse racing come over here? Why do the participants, when they pay the money, the horse racing has to pay the GST has to be paid on the entire face value of the, what they say as a bet over here, and not on only the commission amount. why are they taxing the actionable claim also? So in my view here, I mean, it is clearly a delegated legislation, the rule which is overstepping the parent statute, which in fact it shouldn't have done. I mean, they have done it. I mean, if at all, I don't know whether there is a challenge that is lying before the court. But if, I mean, this can be a good ground for challenge. Why horse racing when it is not a betting or gambling, is not covered under betting or gambling as provided under Schedule 3. So, going ahead. Yeah. So then again, the game of Rummy. Rummy also has been held to be predominantly a game of skill. And again, here, if we see these two judgments of Dream, in the case of Dream 11, Gurdeep Singh Sachar and Varun Grumbar, ultimately what the court has done is that court has painstakingly gone into how the game is being played. Because ultimately it depends on, as it has been held in Lakshmanan's case also, it depends on the facts of the case, in the sense how the game is being played. So the court has understood, it has nicely explained in the judgment also how the Dream 11 game is being played, and then come to a conclusion that it is a game of skill, predominantly a game of skill, and following the judgment of Lakshmanan and the Satyanarayan's judgment, it has held that it is a game of skill and not a game of chance, and hence it is outside, I mean, it's covered under Schedule 3 of the GST. So now a game of chance, games predominantly of chance, and game of skill, as we discussed, it is predominantly a game of skill. So like again, I mean, in the case of chess over here, I mean, one can say that, I mean, of course, it's a game of skill undoubtedly, but the participants who are participating in this game of in this game, where the outcome would depend on the real life match. I mean, it could be said that, I mean, it could be argued to be in a game of skill, because many factors that come into play. He has to do a lot of adjustment. He has to do a lot of decision making is involved, where his knowledge about the game and the player's performance and all this comes into play. And in the case of the second game, which was over is of a Ludo, in the game of Ludo, like as such, there is no involvement of skill, I believe. It is only, I mean, it doesn't matter how do you roll a dice. So that's purely a game of chance. So when it's a game of chance, then I mean, it could be covered under betting and gambling, and therefore the entire deposit amount is liable for GST. But then again, as I said, it depends on how the game. So suppose this game opens only for, say, a last over. There is a last over to be played, or a last ball. You only have 30 seconds to take a ball. Now, maybe Hardik Pandya is batting, so 1 ball 6 is required. So, I mean, even though one could say that I know that this man being at the crease, it could go for a 6. But one could say that looking at the overall scenario, this is a game of skill. But this cricket is a game of skill. But this particular contest as such, it may not be a game of skill. I mean, you have to decide within that 5th ball and the 6th ball, and whether that is going to go. So that could be, I mean, predominantly a game of chance over there. So it depends. I mean, so by looking at the game, then we may have to take a call as to whether it is going to be a game of skill or a game of chance predominantly, and thereafter whether it would fall under Schedule 3.
Ramnath ji, sorry, only one. My basic question still remains.
Sir.
Why we are giving this, so much importance to the game of skill or game of chance, when the schedule is very clear, actionable claims other than lottery, betting. Sir, see, gambling I can understand. Something is gambling, whether it is a skill game or it's a gamble. See, as far as gambling is concerned, you may interpret it by putting the game of skill or game of chance. But as far as betting is concerned, why we are analyzing with reference to the game of skill or game of chance? Betting is betting.
Yes,
and the schedule clearly says,
right,
betting is taxable. Whether it is game of skill or game of chance, I would interpret that way, sir. As far as gambling is concerned, yes, there is interpretation, whether something is gambling or something is a game.
Right.
As far as this thing is concerned, sir, I beg to differ from you.
Okay.
By betting in the first case study,
Right.
Second case study, first case,
Right.
I will say betting, whether maybe skilled involved, data analysis involved, or so much thing is involved, but betting is still a betting.
Okay, sir. So in that case, the horse racing is also a game of, I mean, it's betting. So you are betting on a horse, if you see that way.
Yeah, betting on the horse is taxable. Hello,
Aha.
betting, whether involves skill or no, involve not skill,
Right.
it is taxable. Betting is taxable in my view, sir.
But sir, but then, sir, if you see the definition of betting, that is where, I mean, the element of chance comes. So there are two things, sir. One is that if you go by the definition of betting, and
betting, hey, sir, betting definition you are taking from where, sir?
sir, one I have taken from the erstwhile our service tax law, sir. Okay, sir. I mean, okay, that we can say that it was under the erstwhile law. Then again, what I pointed out, sir, at 31A, if we see that qualifies with a chance to win in a betting or gambling. They are not just saying that it is betting or gambling. They are saying it is a chance to win in betting, gambling, or horse racing. And just stay to that. So,
hey, Ramnathji, what Naresh Bhai's precise point is, be it skill required or not required, the vanilla word you have to interpret betting, gambling means you are out of Schedule 3. That is what Naresh Bhai is trying to say. So let us, I think we respect his view and your view also, then we can proceed on this further now.
okay, sir.
I think Ramnathji, we have dealt enough and given a lot of explanation in this case study too. The Ludo part is concerned, I think it will become repetition in that case because you already covered the Ludo, so you can go to next case study.
Yes, sir. So here it is a case of long-term lease. Sir. A Limited is engaged in the manufacture of motorcycles on leasehold land demised in its favor by MIDC for a period of 95 years. So on that land, A Limited has put structures and it has constructed a factory and it was manufacturing bicycles. Now presently after say 40 years, it intends to transfer the leasehold right in the land with all the structures, the ownership of all structures that it has put over it to in favor of B, and that is for a consideration of 50 crores. Now that 50 crores is towards the premium on the transfer of this lease, as well as it is towards the ownership of the building, and thereafter B Limited has to pay a monthly rental of 1 lakh to A Limited towards the leasehold land. And anyway, I mean, the consent of MIDC is received for this particular purpose. So what is the GST implication on this transaction?
Ramnathji, only go to this previous slide, 40 number.
Yes, sir.
Only on the point number 2, just I want to know, is it really your poser is कि B Limited will pay 50 crore toward the building as well as a transfer, premium for transfer.
Yes,
so
sir.
that means leasehold transfer, that land I will become the assignee now and it will come in my favor with the consent of MIDC. Now in that case, where is the point of my paying rent to A now? Because now MIDC and I am concerned. Why? Because A has transferred that leasehold right in my favor on the record of MIDC. Then I mean to say your case study may this line is relevant now. We'll pay 1 lakh rupees to A Limited.
I mean, in the case of long-term lease also, they will be charging an upfront amount and thereafter a rental will be charged. So
actually, this is a case of assignment of lease because you say tri-party MIDC premium they will be paying for transfer.
Right, sir. Right. They are transferring the leasehold. They are assigning the leasehold right in the land, and along with that, I mean, going forward, it has to pay a monthly rental, sir.
So on the record of MIDC now it is B Limited who is assigning.
Yes, sir.
So then also rent has to be paid to A. Fine, no issue. You have drafted the case study. That's okay. Fine.
Yes, sir. I mean, it has in fact. I mean, what I could find out is that this is a real issue. So
okay.
They would have been. They are
no issue. No, thank you, sir. So, shall I give some input on this, sir?
Yes, sir.
So this the question comes is here the long-term lease, whether it is tantamounts to transfer of immoral property or no, that's the issue.
Right, sir. Okay.
Now, unlike service tax, the provisions in GST are not at par as regard these transactions are concerned. And the Schedule 3 is talking about land and building.
Right, sir.
In
Sale
that
of land.
entry 2 of Schedule 3,
Right.
that is only talking about land and building.
Right.
And whereas Section 7, which is talking about the supply, and Section 7, first you already explained that first all the test of Section 7 you have to pass, and thereafter you have to go to Schedule 2 only for classification, whether it is a service or goods, as the case may be.
Right.
Now there
Right,
is a second entry in Section 7. Now first, whether it is a transfer, sale, barter, exchange, that is what is been defined in Section 7 to be a transfer. Sorry, supply.
Right. Okay,
And
sir.
then having done that, you go to Schedule 2, and Schedule 2 there is a second clause where land and building, and then they have used the word lease, tenancy, easement, license to occupy land, etc. is a service for the purpose of GST.
Right, sir.
Now, only issue is, although we have in this case it's a long-term lease which is maybe under the TOPA, etc., it may become transfer of immovable property. But the having specific provision which is covering these aspects in supply under GST coming out of taxation for this transaction will be a big challenge, and it will be treated as supply of service in my view. The premium is concerned.
Okay, sir. Okay.
Just to add it, the writ being filed, and that is of in Mumbai High Court.
Yeah.
But the only thing is about writ, I would only like to add it up. One thing is, although the court says that it was challenging the validity of the provisions, but that was prior to that amendment of Section 7.
Exactly,
Section
sir.
7
Right.
has been amended retrospectively, but it was in February 19.
Right.
And this writ was decided in August 18.
Sir. You are absolutely right, sir.
So I just also want to know whether the court would have opined other way around had this decision was pronounced post February 19, considering the amendment or retrospective in the GST law related to Section 7. That is something which we would like to know. That is one. And of course, advance ruling is concerned, we don't rely more as regarding the GST is concerned, but still one of the advance ruling of West Bengal in case of Enfield Apparels, which has dealt with this. Of course, there they have almost the long-term lease, and which is going on this, they say it is a service. Of course, I'm not harping more on advance ruling, but it's just a remark that advance ruling also tilt toward that it is a service.
Okay. Because lease does not distinguish between a long-term lease or a short-term lease. A lease is a lease. So, I mean, therefore, it is a supply. Okay, sir. Okay.
Ramnath ji,
Sir.
just one thought was hovering in my mind for last so many, from the day this provision was introduced.
Sir.
When you are transferring, see, this is very, very relevant as far as Navi Mumbai is concerned, and everywhere, the land is always on the leasehold.
Sir.
And you construct the factory and you are selling the factory building, completed factory building.
Right, sir.
So can I take an argument? Okay, what I am selling is a completed building, and the land on which building is situated, the land is already married to a building. Land is appurtenant to the building. So what I am selling is building only. Only for the title documents and other thing, the law wants me to get it assigned in the favor of the buyer. When I'm giving the consolidated consideration of 50 crore rupees for land and building. So I am not separately assigning the land in the favor of the buyer. I am my intention of both the parties is to buy the factory building. And there's a concept we call it, the land married to a building. Once the building is constructed on the land loses its sort of land loses its existence. It gets converted into the sort of building. It becomes a part of a building. So I think see, if you treat the leasehold land separately, and if you are assigning it and you are taking consideration for it, then as Rajiv Bhai has said, the chances of getting it taxed are very, very high, because they are saying what is excluded from the definition of supply is only sale of land. And when you are leasing out of land or we are assigning the lease, you are not selling the land. So though practically you are selling the land, but legally you are not selling the land.
Yes,
So just,
sir.
just one thought, if you
Okay.
can throw some light on that and your views on that, sir.
Right, sir.
Uh,
Right.
Naresh bhai, just to add in this, Ramnath sir, now this is a leasehold land. First of all, I also want to know, can we sell the lease of land at all? Because
No,
there is a
we
tenure
can't.
of the lease. Maybe
Right, sir.
60 or 90 years.
Right.
At the end of the tenure, the property goes
Goes
back
Goes
to
back.
the
Yeah,
lesser
yeah.
only.
Yes, it is. There is no ownership transfer that's happening. There is
So
only the
maybe by and large it gets renewed on paying some premium. That's fine. So there is once in case of a transfer, I have to rest assured it's a freehold and nobody
Right.
will have claim on it whatsoever, and I will not go to anybody for
Right.
anything I want to do. But this being a leasehold, and secondly, what Naresh Bhai has stated here is that I am predominantly selling the building, and land is married to the building to that extent because it is already embedded within that. That's what Naresh Bhai is trying to say. I only want to say in the preface of that agreement, I'm sure the document which you will prepare, in that you will mention it is on a leasehold property.
Right, right.
Lease
It
has
will.
been given by
Yes,
MIDC
yes.
for so
Definitely
many
will
number of
require.
years, and it is going
Right.
to expire over a period of time, etc., etc.
Right.
And that too also you will mention that there is a consent to be taken at the expiry of the
Right.
tenure or even for this transfer.
Right, sir. Right, sir. It will be very clear that it is on a leasehold land, and what is being transferred is only the leasehold interest in the property and the building which I have constructed on it, which I am the owner of the building. So land does not belong to me. It's a leasehold land, and the building what is constructed on it belongs to me, and I am selling the building. So I'll cover that in the next slide, sir.
Fine, fine. Thank you.
Okay, sir.
Ram,
So,
Ram
sir.
Krishnan here.
Sir.
I just want to say
Sir.
that in actual fact, the MIDC,
Sir.
when it allots the land, it charges a premium,
Right,
okay,
sir.
a huge premium
Right.
for the lease. But
Right,
one
sir.
important thing is that is subject to, look, they don't want people to trade on land. It's subject to in 3 years' time, you will construct a building.
Right.
So first is agreement to lease. So at that point, you're only a licensee. Once the factory is constructed, then the lease is of the land and the building together. So the person who has constructed his building does not have ownership rights on the building.
Sir, I think
Because the condition of allotment,
Uh,
the condition of allotment is once the building is completed, the lease will be of the land and the building. Though you may say that the money was spent by the licensee or the lessee, but it will be there. And after 99 years, the building and the land will revert back to MIDC.
no, sir. I mean, if you see section 108, there is a provision which says that you have put the building, you can remove the building. I mean,
That
you are
is
in fact
no-
the owner of the building.
That is the Transfer Property Act. But
Right.
if you look at the MID Act,
Okay.
MIDC, if you see any document of MIDC,
Sir.
the very condition of allotment, because the parties can contract to the contrary. The very condition of allotment is that when the factory is constructed, you will have to agree to the lease of the land and the building. So my suggestion to you is, when you consider answering this query, you consider on 2 points. Consider that your facts, that the A Limited, because we also know that the ownership of land can be different from the ownership of the building on which it stands. We are all aware of that on the normal law.
Right.
So when you answer the way you have taken, that if it is a, because we also seen balance sheets also, no, where you have leasehold rights, where it's amortized, and you have factory building where depreciation is claimed.
Right.
Okay. So that is the general understanding of everybody. But
Right.
if you look at the MIDC documentation,
Yeah.
the MIDC documentation says, once you have constructed the building, you give me the lease. I will give the lease of land and building. This is contrary to logic. And what you'll think is by land, I spend the money. But
Right.
they always believe that they want to, if they have to proceed against you, later on, you should not hide behind that this building belongs to me. So that is
Okay.
why
Okay.
the
Okay.
in actual practice, if you see any MIDC document, after the building is because there are three stages. One is allotment, he has an agreement to lease, where you become a licensee only, and once a factory building is constructed, you get the lease only after the factory building is constructed. Till then you are a licensee. It's only an agreement to lease. And once you construct the factory, the lease is of the factory land and building. So my request is
Okay.
you take both scenarios on the assumption that building belongs to A and on the assumption
Huh.
that the lease is there. That is my
Okay.
request.
Okay. In that case, the interest is transferred of both and the land as well as the building is what you are saying.
So I will tell you in actual practice, since you have taken MIDC and I am familiar with it, actual practice what happens? First it is allotted, land is allotted, you pay a huge premium, then an agreement to lease is given, the A limited is licensee, he has to construct the building within 3 years because they don't want people to speculate on land. Then once you construct the building, the MIDC will give you a lease of both the land and the building. Now, after 50 years or 30 years, you want to transfer the land and building in the leasehold rights. MIDC says, you can transfer, we have no issue, but you require our consent. That is there at the time of allotment itself. When you go to the consent, what they say is, you enter into a assignment deed between A limited and B limited, and that assignment lease is subject to our consent order. We will give you a consent order, but our consent is subject to you paying a premium between today's rate for the land, which you charge, minus what you paid us, say, 50 years back. That is called differential premium. And then once the consent order comes, these people A limited assigns the rights to B limited. That is what actually it happens.
Krishnan sir, only one thing is there. The MIDC, so far so good. What you say is fine. Only one liner. Suppose I am a original lessee of land from MIDC and I have constructed building. In your talk, you stated that the lease will be for land and building both. Within 3 years time, I construct. Now, suppose after 10 years, I transfer it to you. We have a case in that there are two documents executed between me and you. One for assignment of land and one for sale of immoral property building specifically, and which is known to MIDC. And so suppose the price is 5 crore for land value and 50 lakhs for building. The differential, etc., and the NOC or permission what is being required for MIDC is only for land, not for building.
No, you go through the document
Achha.
and look at the consent order.
Okay.
I'll tell you what people to do planning, no? They are deliberately showing separately.
Yeah.
Because in their balance sheet, they are never showing as leasehold building.
Yes.
They show factory building.
Correct.
And leave it at that, and they have been claiming depreciation.
Correct.
Because the building, each brick and mortar belongs to the A limited.
Correct.
So based on that, they say it is our building.
Correct.
And they have two such things.
Correct.
But actually, the document of lease will always show that the lease is of the land with building.
Yeah. Okay. Fine.
Okay. This is the actual practice. Because why MIDC wants to do like that? See, we also were not sure about this. We also had to investigate because we believe that money is spent by A limited. How can MIDC say, I am giving you something? You can't give me something which it is mine.
Yeah, absolutely.
You can't give me.
Correct.
But MIDC says, no, we have, that is the terms of my allotment. Because the reason tomorrow, if you want to proceed against you, you should not go to court and say, I can't give the land because the building of mine is standing there.
Fine.
That is the purpose of giving this.
Correct.
But I don't want to upset the Ram's rhythm
Sir, what I
of
can...
articulation of his solution. You give the solution on both. Assuming the building is A limited. In
sir.
fact, in that case, as Rajiv says,
Ah.
A limited to B limited, there will be two documents.
Right.
One document of assignment of the building, transfer
Right.
of the building.
Right.
Another document, assignment of the lease.
Right, sir.
And in the lease, MIDC only gives a consent order.
Right.
They don't become a confirming party.
Right, sir.
Okay, because what MIDC wants to say that you already have got a lease for 99 years. You are only transferring the lease. Okay, I am giving a consent. That is all.
Yeah.
Okay, sorry for
No problem.
butting in and perhaps changing your
Nice, sir.
chain of thought.
Nice, sir. Nice.
But I just thought, let me bring the thing to the actual ground level, and you can deal with both, on both the.
Okay.
Sir, one of the fantastic inputs you have given, sir. This is something,
Yeah.
Many of us are not knowing, this particular depth that you have discussed.
Yeah, I also would not have known, but last 10 years I am on this.
It will change.
Because I am fighting MIDC's case, no?
Yeah, I know that, sir. I know that, sir.
Otherwise, I would not have known, because I have done of my clients who are owning MIDC land.
Yeah.
And like all auditors, I also mechanically used to see factory building here, lease of land there, lease of land amortized, factory building depreciation. This is all I have also done.
Thank you, sir. Thank you for great inputs.
No, not at all. I must have only upset Ram's chain of thing. And you can, let me tell you, you can give the answer in both scenarios. Because there could be some other case where the leasehold will be only of the land, and there will not be of the building.
Okay. Right, sir. Right. Sir,
on a lighter side, Krishnan sir, Ram was on up. You have set him. It is not upset.
Yes, sir.
No, I understood.
Okay.
Sir. So, we are now aware as to we are discussing about this. Trying to fit this in para 5 of schedule 3. So before going ahead, if you see this schedule 2 para 2, which is nothing but a classification of whether it will be a supply of service or a supply of goods. So it has said that any lease, tenancy, easement, license to occupy land is a supply of service. And again, we had discussed all this. So here I would like to, get into this one small aspect, sir, which, how the English law, as I think Krishnan sir is already, told about this. In the English law, one can have a land and the other person can construct a building and say that, I am the owner of the building. But in the English law, it is what is annexed with the soil goes with the soil. We have many judgments over here to say that I have a land belongs to one person, whereas a building has been put on that by another person.
Sorry.
Hello? Yes, sir. So we know the intention, what the government of the government. So notification have been issued 12 of 2017, which there is an exemption when state government industrial undertaking gives a long-term lease and an upfront amount is being charged like a premium. So there is an exemption. And also in the case of residential long-term lease also there is an exemption, and the tax is payable only to the extent of unoccupied apartment. So the intention is clear that they want to tax. Now here is a leasehold assignment that is happening. Interest in the land is being transferred not from MIDC to A, but it is A who is transferring it now to B. So whether on that premium what he is charging along with the building what he is, the ownership of the building, what I'm saying is transferring, will be liable for a GST, or for the time being we can just exclude the building and we can say that it is only the land that he's assigning, or a private person who's having a land is transferring the lease, or is entering into a lease agreement, a long-term lease agreement with, say, Mr. B for 99 years, and is charging a premium, as well as there will be a monthly rental what is being charged. Now that is clearly not covered under this notification, because the lease is not being given by any state government industrial development corporation. So therefore, it is between private parties, and there a premium is being charged, and will that be taxable to GST? So without bringing in MIDC. So as this we have already, Rajiv sir has pointed out, I mean the law insofar as this issue is concerned, now the Bombay High Court says that what I have highlighted, it is that, I mean, the premium or one-time premium is a measure on which tax is levied, assessed and recovered. So they don't want to probe much into it. So insofar, even though this was rendered prior to the amendment to 7(1) to section 7, but the law is that, I mean, the Bombay High Court has considered, and it has held that long-term lease, the premium that is charged is liable for GST. So that is and this is in fact now pending before the Supreme Court. So now, before that, I would like to just get into this, what is a license, easement versus lease, because this is the expression that we see in para 2 of schedule 2, where, you know, we have considered what will be a supply of service and what is a supply of goods. So when it comes to land owned building, the supply of, the lease, rentals and license to occupy a land is said to be a supply of service. So what is, I mean, a license? So license is defined under the Indian Easement Act, and as we know that license is nothing but a permission, or, you know, a right, without which the act that would be done would be an unlawful act. Like we have seen in the sales tax cases, like whether the forest license which was given for fetching bamboo from a forest or tendu leaves, whether it is sales tax is leviable on that or not. So it was said that, you know, it is nothing but a mere license. You don't get to possess the land. There is no interest of any sort that gets transferred, but it is only a license that the forest department gives. You just go collect whatever you have to and you come back. So you don't have any possession over the land. Then next is, I mean, what is defined, what is covered under the same para 2 of schedule 2 is the easement. And again, easement is the same thing. You don't get any interest over the land. It is only a right. Like, you know, the example, what it is there under the Easement Act. A, as the owner of a certain house, has a right to go to the neighbor's land and take water for the purpose of household out of the spring therein. So therefore, this again is a right, is an easement. Now, but when we come to lease, lease is being defined under 105 of the Transfer of Property Act, and in the case of lease, is defined as a transfer of a right to enjoy such property, and the consideration is paid as a premium or a renter. So lease, in the case of a lease, it is not a license, it's not, of course, not an easement. So here you get something more, you get to possess the land. So that's the difference between license and lease. You get the possession of the land, and also the interest is being transferred in the case of a lease. So, but why is this, we are saying in the case of long-term lease, I mean, it is not liable for GST, earlier it was for service tax. So coming to that, first I would like to go into this lease, where it is coming in the CGST Act. So if we see again what was earlier I had said, Schedule 2 of Para 2. So here, the lease, if we see, is in the company of the words tenancy, easement, license. So in none of these, you are only getting something to enjoy, and there is no interest as such that transfers apart from lease. So lease also is defined where transfer of right to enjoy a property happens, but a consideration is a premium as well as a rental. So I would read this expression lease, what is coming under Schedule 2, only to the extent that it is nothing but for enjoyment of a transfer of right to enjoy the property, and not in a lease where there is a transfer, or one is parting with an interest in that land, or there is a transfer of interest in the land for which he is receiving a consideration. That is not something for a right to enjoy the property. So that should not be taxed. So therefore, lease has to be read something, a rental is received and that rental is towards the enjoyment of the property. Now, why I am saying this? Because this has been nicely explained in the judgment of Greater Noida. Now, this is found by the Allahabad High Court. So this is after considering the Panbariti, which in fact has not been considered by the Bombay High Court, in the sense they are saying this is the case law under the Income Tax Act, where the tax is on income and it was whether it's a capital income or a revenue receipt. So therefore, we don't have to get much into that. But this judgment very nicely explains it. So a lease is a transaction which has to be supported by a consideration, and this judgment says that there is we cannot distinguish a lease as a short-term lease or a long-term lease. And then it goes on and says the consideration may be either a premium or rent or both. The consideration which is paid periodically is called rent. As regards premium, then it goes into the Panbariti Supreme Court and says has made a distinction between premium and rent, observing that when the interest of the lessor is parted for a price, the price paid is premium or salami, but the periodical payments for continuous enjoyments are in the nature of rent. The former is the capital income and the latter is the revenue receipt. Thus, the premium is the price paid for obtaining a lease of an immovable property, and whereas the rent is for the enjoyment of the property. Therefore, a lease covers a long-term lease, but to what extent you can tax is only the rental that is being charged for the transfer of right to enjoy the property, and not for when the premium is paid for because you are transferring an interest in that property. Now, that is what I would say that is nothing but a benefit that arises out of land. It's as good as a land, and therefore it is. You cannot charge either earlier service tax or now GST. Uh, the other point being, again, of course, when one enters into this can't be the sole reason, but this is one of the argument like one can take in the case of lease. When a leasehold deed is being registered, uh, it has to be registered with the sub-registrar or any authority for that matter, and then you have to pay the stamp duty at the ready reckoner value. That is, it's as good as paying the stamp duty on the sale value of the land. So therefore, this is one of the arguments generally taken to say that in the case of long-term lease, the premium is not taxed because that is that's on which you pay the stamp duty, and therefore it is not liable for. It's outside the center's purview to tax, whereas it comes under the domain of the state. So that is the third. And here, but the point is, if we say this, the rental is only charged for enjoyment of for a transfer of right to enjoy the property, whereas a premium is not a consideration or a quid pro quo for any service, but it is only a parting with an interest in the land. The department can always say that. Okay, now we can see the definition of the charging section, that is section 9. It says tax shall be levied on intrastate supplies of goods or intrastate supplies of services. Now, if you see the definition of goods, it says anything that is movable, including actionable claims and excluding some things. And whereas if you see the definition of service, it is anything other than goods. So therefore, naturally, the question is that will immovable property also be get covered under the definition of service, which the department is definitely going to take a stand that it is all covered under service tax. Under the definition of service. So I would say that first of all, it does not. It's very absurd to say that there are only two things. One is that goods, and the other is service. There is no third category at all. Services includes immovable property. It's an absurd argument, but nonetheless, one can take that. The department is definitely going to take that. But then, if you see over here, this is what the Supreme Court has explained in these two judgments. That is, All India Federation of Tax Practitioners and Association of Leasing and Financial Services Companies. So here they discuss about something called as a theory of equivalence. So I would feel that if this argument is taken, the theory of equivalence fails. So what is this theory of equivalence? So now this Supreme Court says that there is no difference between uh, a tax on, because both sales tax as well as service tax are consumption tax, and there is in fact no difference between the two. One is a goods tax. I mean, you consume the goods and therefore you are paying the tax, and now it's a service tax where you have been rendered with the service. Both satisfy human needs, and therefore one is a goods tax and the other is a service tax, and now they are both together, and it is a goods and service tax. But now if we say that this service is so broad enough that it would include the immovable property also. Now we are equating all three on the same plane. One is the goods, the other is the service, which goods, which is a movable property, and then a service, which also we are saying that includes immovable property. So therefore, absolutely there is no difference between a movable property and the immovable property. That, in my view, I mean, that would be wrong to include an immovable property under the definition of service. I mean, we can rent it out, and that renting could be considered to be a service. There is maybe an element of service. Of course, that is also now challenged in the case of whether renting itself is a service or not. But I mean, I have an immovable property, I can rent it out. There, a transfer of right to enjoy a property is happening, which is a service, and I'm receiving a consideration. So that could be taxed. But to say that when one is parting with an interest in the property and receiving a consideration, and that is always the courts have held that anything, those interests which emanates out of a land are nothing but equal to land, benefits that arise out of land. That to tax, saying that it is service, I mean, in my view, it is not right. So coming now to this case study. Uh,
Ram, can I add
yes,
something?
sure.
So your point is that the definition of service cannot be stretched to cover the transaction of sale of an immovable property or land and building.
Right.
So assume for a moment that entry 5 in Schedule 3 was not put by the government in Schedule 3.
Right.
That is, sale of land and building is not a supply.
Right, sir.
That entry was not there. If that entry was not there,
yes, sir,
will we still keep arguing that sale of land is not a service?
In my view, that
will
would not
succeed. Will we succeed in that argument?
Yes, sir. In my view, that wouldn't have made any difference. According to me, it wouldn't have made any difference.
Okay.
So
even though the definition of service is anything other than good.
Yes, sir. It can't be said that anything or everything under the sun gets included under the definition of service. It can't be read to and stretched to that extent. I mean, of course, they have a right to, deem anything as whatever they want, but still, a deeming fiction has to be something, which makes sense. It can't be stretched something to make something, illogical.
And second point is, if the lease were for 9 or 10 years and not 30 years and 99 years, or even 999 years, at Altamont Road, there is a plot of land given by the in 1936 for 999 years.
Right, sir.
So, if this were the period of lease were different, 5 years, 7 years, 9 years, will our answer change?
Right. So in my view, I think the answer should not change, sir, because if I am charging a rent for for letting out an immovable property, what is called as I call it as a rental. That yes, you can tax, but I am charging something for parting with an interest in the property. That should not be. That is not for the right to enjoy the property. That is nothing but parting with an interest in the land. That it's like a development transfer of development right, where I am transferring that person is also the builder is interested in the land. He will construct and he will see to that the apartments are being sold. So the interest gets transferred. So it is not that merely he comes, he works and leaves. So the interest is parted from the landowner or transferred from the landowner to the builder. So that, in my view, is the interest in the land, which is the benefit that arises out of land. One can argue and say that that is not within the that's only the exclusive domain of the states to legislate. They can.
And the third point was on your Nositara Sokai that lease tenancy easement, the way the words are placed in Schedule 2. But the same word lease, when it comes to Section 7, is placed alongside the word sale, barter, exchange, license, lease, rental. So
Yes, sir.
Has there we are prepared to take the color which is wider for
Yes,
a lease.
yeah. But
And
here, yes, but here and they're specifically saying, I mean, when it comes to land and building, Schedule 2,
no,
Para 2,
I'm saying there is no such exclusion in Schedule 3.
Schedule 7.
First hypothesis,
Right.
right? Only Schedule 2 is there. Schedule 3 there is no exclusion.
Yes, sir. Schedule
Then
3, it's not, let's say that, I mean, it should not matter even if that's not there in Schedule 3. We will go only by what is there in the charging provision and the scope of supply.
okay.
Ram.
Yes, sir.
Sir, we would have loved to continue for a long with the way the case study and the interesting topic you have selected. But the only request is we are at 7:30, which is a scheduled time. So we normally call a rapid round. Now last two case studies are left out, which I think it will be unilaterally. You will have to give the views on it without any discussion. Then we'll able to get at least your view and we'll able to conclude on this file. So I think this should be fine with you. My apology for inconvenience, but we'll be exceeding the time otherwise.
No problem. And in fact, these are very straightforward case studies. I mean,
Fine.
Made to
So,
look slightly complex, but they are.
So you can straight give your views on this now.
Yes, sir. So, here, I mean, A Limited, who is located in Mumbai, receives an order from a customer who is located in Singapore, and he purchases the goods directly from Vietnam and instructs the vendor directly to supply to Singapore. So it's an out and out transfer. The goods doesn't come to India at all, but he records in his books as that it's a purchase, receives the foreign, pays in foreign currency, and it's also recorded as purchase, sale, and also the amount is paid to the vendor in foreign currency, also receives in foreign currency. So what is the GST implication of this transaction? And secondly, with regard to, he will be having many credits over here. I mean, he would be paying rent and LC opening charges, and there are many common input services also. So will he be entitled to take credit of these input services? Because if we go, I mean, we are to say that he does only 2 transactions in a whole year. One is that he may do this kind of out and out transaction, and then he may actually physically export the goods. I mean, first import the goods, and thereafter he may export the goods. He does both. So 2 kinds of transactions. So how would he go ahead and file his refund claim? So here, I mean, there is one AAR, which, I mean, in fact, just had to say that this is covered under Para 7 of Schedule 3, supply of goods from a place in the non-taxable territory to another place in the non-taxable territory without such goods entering into India. It completely missed this particular, even though it's a recent AAR, missed this particular entry in the schedule, and it goes on and analyzes that there are 2 kinds of transactions over here. One is that the goods doesn't come to India, so therefore the question of filing bills of entry does not arise. So therefore there is no customs IGST payable. But at the same time, the other leg of the transaction is not an export, because goods are not going from India to a place outside India. But however, then it reads section 7.5a and read with section 10a and concludes that this is nothing but an it's an interstate supply liable for IGST. Anyways, now we know that this is a transaction, I mean, from a non-taxable territory to a non-taxable territory. We'll go ahead with the availment of credit, and how do we go for a refund if at all he makes any zero-rated supplies along with these kind of transactions. So quickly, section 16, one could take the credit of supply of goods or services used or intended to be used in the course or furtherance of business. So it is definitely in the course or furtherance of business, so I'll be entitled to take the credit. And section 17.1 takes that it comes about with the reversal. If at all I am using receiving the services for the purpose of business or partly for other purposes. So if at all if it is only for the business purpose, to that extent I will be entitled for the credit. And similarly, when it comes to the exempted supplies as well as taxable supplies, if at all I am making an exempted supply, we have to reverse to that extent credit. Now the question is, now these are common credits, and these are out and out supplies. Goods are not coming into India at all. Schedule 3, I would say, Schedule 3 transactions. So by making a Schedule 3 transaction and receiving these input services, will I be entitled to take the credit of that or not? Or will that be treated as an exempt supply, these kind of transactions, and therefore warrants reversal to whatever extent? So now here it is clearly provided under 17.3 itself, there is an explanation. So it says that the expression value of exempt supply shall not include the value of activities or transactions specified in Schedule 3, except those specified in paragraph 5 of the shed sheet, that is sale of land and sale of building, but we get covered under otherwise under Schedule 3. So therefore, this explanation makes it clear that for the purpose of this subsection, that is subsection 17.3, the exempt supplies will not include the Schedule 3 transactions. So that means I am not, required to do any reversal, and I'll be entitled for the credit to the entire extent. That is, on this, I'm doing two kinds of transaction. One is Schedule 3 out and out supplies, and also actually importing, and thereafter I'm exporting. So there is no reversal at any stage that is required, going by this explanation. Now, if you take this slightly forward, he is also doing zero rated supplies, that is, he is exporting. Now, to what extent he will be claiming the credit is fine, you can retain it, and then if at all there are any domestic supplies, you can make use of it. But how would he go ahead and claim the refund of this amount to the extent of export is being made? So if we see under 54.3, it is only in relation to zero rated supplies, of accumulated credit, you can go ahead and claim the refund. Zero rated supplies exports. And 89.4 gives us the formula, how to calculate the refund in the case of zero rated supplies. Now, refund amount is nothing but zero rated supply, that is my export turnover, divided by my total adjusted total turnover. Now, ITC, what is net ITC? Net ITC is nothing but my total credits, and if at all there are any reversal on account of exempt supplies, I should have made it. But here it clearly said what we saw in the explanation, there is no requirement of any reversal when it comes to Schedule 3 transaction. So my net ITC will be the entire credit that I have claimed. Now coming to zero rated supplies, anyways, it's the export turnover. But what is adjusted turnover? Adjusted turnover means the turnover in the state or in the union territory as defined under Section 2 of Section 112. So now if we come to Section 2112, it says it is the value of all taxable supplies. Well, I don't have any taxable supplies, and the question is again whether my exempt supplies will include these transactions or not, because if we have read that carefully, the explanation, it says that for the purpose of this subsection, that is for the subsection 17.3, exempt supplies does not include Schedule 3. So one can argue that that is only for that subsection when it comes to reversal under Section 17. But whereas when it comes to the formula, the total turnover in a state, exempt supplies, anyways, we have to examine that whether exempt supplies is a broader exempt supplies as per what is defined under the definition of exempt supply. So whether there again Schedule 3 can we say that is included or not, and again the total turnover includes the zero rated supplies. So now exempt supplies. So what is the exempt supply? Exempt supply means the supply of goods or services or both which attracts nil rate of tax. So again here it begins with saying that it is the supply of goods or services or both. So my Schedule 3 transactions are neither supply of goods or nor supply of service. So we know that for something to become exempt, first it has to be a supply. So here it is not a supply at all. So I can say that it does not get covered under the definition of exempt supply. And it also includes non-taxable supply. So what is non-taxable supply? So non-taxable supply means supply of goods or services or both, which is not leviable to tax under this Act. So therefore, again over here, it is the supply of goods or supply of service. So it has to be a supply. So again, Schedule 3 are nothing but it's neither a supply of goods or neither a supply of service. So therefore, it is not an exempt supply in my view. So what would happen to the formula in this case? So it would be a situation where I will be taking my total net ITC because I don't have any reversal insofar as the exempt supplies are concerned, and it will be multiplied by my total zero rated supplies. That is, suppose say that I have 1,000 crore turnover, 500 is my export turnover, so that 500 crore will be my zero rated supplies, and I'll be dividing that with my, what should I divide it? Aggregate turnover. What is aggregate turnover? Aggregate turnover is nothing but my taxable supplies, which is not there in this case, plus zero rated supplies. Of course, it is there 500, plus there is no exempt supplies because these transactions are not exempt supplies. So the numerator will be 500 and the denominator will be 500. So I would be entitled in this case to take the refund of the I mean, for the entire amount. I mean, so that's what I wanted to discuss. If at all anybody has a view, I mean, is this a wrong approach or is the approach is right? Because one can say that you are entitled to take the credit only to the extent of zero rated supplies, whereas now here you are taking the credit of the the refund of the entire amount of credit, which includes these kind of transactions also. The services have been made used for providing these out and out transactions, and so that extent also you are taking the refund. So in my view, I mean, the formula, it's how it is being provided. If you give the meaning, I mean, go by the meaning what is provided to exempt supplies and non-taxable supplies, I mean, so you will be entitled to take refund of the entire amount in this case. And so, and the last one is of inbound manufacturing. I mean, I'll not get into because we just made a case study out of this. So here what happens is that A Limited has a license under section 58 of the Customs Act and also has received a manufacturing license under section 65. I mean, this is under the new regulation that has come about, which is the, yeah. This is the Manufacturing and Operations in Warehouse Regulation 2019. So, you know, a person can apply for a license as a private, a factory can be converted into a private bonded warehousing license, take a license and also manufacture under it. So, when the goods are imported into the country and when a person can file a bill of entry for home consumption and pay the duties and clear the goods. But if at all the goods are not required, he can file a bill of entry for warehousing. So here the government has given an option, that is, you know, you can apply for a warehousing license and also at the same time undertake manufacturing in that. And if you are exporting the goods, there is no requirement of paying any customs duty. So so in this case, I will import the goods. I will file the bill of entry for warehousing. The goods are warehoused, and thereafter the goods are manufactured goods are cleared locally to within India. So in that case, I have to pay the GST as well as the customs duty, which is being deferred till the goods are manufactured and cleared. But one thing that can happen, and I mean, it's provided under Section 67 of the Customs Act as well as these regulations, is that you can transfer these warehoused goods, which from one warehouse to another warehouse in the country. Like, you know, this warehouse is in Thane. He has imported the goods, filed the bill of entry for warehousing. The goods are not yet manufactured; they are still warehoused goods, as per the definition under the Customs Act. You can then transfer under bond these goods from Bombay to Chennai under a bond, and the goods in that case are not cleared for home consumption yet. So the movement may happen within the country, but you know, there is no GST implication in this kind of transactions, and that would get covered under what is being provided under this para 8 of the schedule 3, supply of warehouse goods to any person before clearance for home consumption. So this is what I wanted to cover in this last part.